Yes,
Thank,
please.
thank you. This appeal hearings in the matter of case number CA014-2022 before Chief Justice Zaki Azmi, Justice Lord Angus Glennie, and Justice Sir Peter Gross. The appellant is represented by Watson, Farley and Williams Middle East LLP. Lead counsel is Ms. Charlotte Bijilani. The respondent is represented by Jalaf Advocates and Legal Consultants. Lead counsel is Ms. Amna Jalaf.
It's Amna Al Jalaf. Amna Al Jalaf. Okay. Yes. Can you brief Miss who's the appellant? Miss
Vigilani.
Bijilani. I'm sorry, Bijilani. Can you in brief, tell us what your case is, what you're relying on? Very briefly, tell us
Yes,
before you
of
proceed
course.
on with your full submission.
Of course. So this hearing is in connection with committal orders that were issued by Sir Justice Jeremy Cook, and they were issued in relation to the defendant company A&K Trading Limited, but also in relation to two of the directors and shareholders of the company, Mr. Abu Ali and Mr. Abu Hashima. And those orders stem from a breach of a freezing order issued by Sir Justice Jeremy Cook back on the 14th of January 2022, which prohibited the respondent company from moving assets from the jurisdiction, but in particular prohibited the removal of an aircraft from Dubai airport. And after a lengthy hearing, Sir Justice Jeremy Cook found that Mr. Abu Ali and Mr. Abu Hushima were in contempt, as well as the respondent company. And Mr. Ali applied to purge his contempt, and the order by Deputy Chief Justice Al Madani in September of this year purged his contempt without the claimant having the opportunity to make any representations about the purging of the contempt. And
that is your main principal issue, isn't it? You were not given the right of hearing.
That is correct. And we're also advancing a case that Sir Justice Jeremy Cook envisaged that there would be a discussion about what the terms of the purging of contempt should be. And he does references, I can take it to you, to the relevant paragraph in the detailed reasons he gave. But the order that he made in these proceedings and in the context of the committal orders was that not only the principal debt that's due under the aircraft management agreement is paid, but also interest on that sum and assessed costs of $288,000. And when the orders for contempt were made, they were made without Mr. Ali and without Mr. Abu Hushima and without a representative of the respondent attending the hearing. Despite them knowing about the hearing, they didn't attend. And when the orders were served, they didn't do anything to ask for forgiveness at all. Instead, they continued to pursue onshore court proceedings in Dubai, maintaining that this court does not have jurisdiction at all. So not only have they acted in contravention of the injunction, they've done nothing in relation to the committal orders made against them, and have not come to this court to apologise until such time as the Attorney General in Dubai took action, which is the procedure under the DIC court rules. Once the committal order is made, one option that's available is for the judge to refer the matter to the Attorney General of Dubai. And such an order tends to be made where the contempt is particularly serious. And the Attorney General, as we understand it through assistance by local council, issued summons and I believe stopped Mr. Ali and Mr. Abu Hushima from travelling. And it's only when that happened that Mr. Ali came to the court and wanted to purge his contempt. But the issue that we have is that he's only paid the principal debt. The order purging his contempt was made without the claimant having the opportunity to say what the conditions should be in their opinion. And I've also noted that Miss Al-Jalaf, in the skeleton argument that she's filed, is not only seeking a ruling that Mr. Ali's contempt is purged, as well as the respondent, but also that Mr. Abu Hushima's contempt is purged. And I should explain that although Chief Justice Ali Al-Madani had made an order purging Mr. Ali, he had not made an order purging the contempt of Mr. Abu Hushima. But because the Attorney General treats the matter as one file, the consequence of the Attorney General lifting the complaint against Mr. Ali is that the complaint has also been lifted by the Attorney General Office against Mr. Abu Hushima. And the other point I should raise is that in the lead up to this hearing, we had asked Ms. Al-Jalaf to state who she acts for. And that was done because it's a theme, it's been a theme throughout these proceedings that Ms. Al-Jalaf refuses to say who she acts for. That certainly came up, as you'll see from the reasons that Sir Justice Jeremy Cook gave in the contempt proceedings. It again came up when we had a meeting at the court that the registrar arranged to discuss the situation after the purging of Mr. Ali's contempt. I again asked her, and there's a transcript of the meeting in the bundles, which I can take you to. I again asked her who she's acting for and whether she is appearing on behalf of Mr. Ali, Mr. Abu Husima. She refused to answer the question. And again, then in the email that we received from her law firm on the 29th of November, she now says that she's appearing today as a representative of the respondent company and Mr. Ali in his capacity as a director and shareholder in the respondent. She does not say that she's acting for Mr. Abu Hushima. So I don't see how she can be submitting a skeleton argument asking for Mr. Abu Hushima's contempt to be purged when she isn't on the record for him. So sorry if that's a long, rather long explanation.
Very long.
But,
I thought you would do it so in 2 minutes.
There's a lot of detail to the case, I'm afraid.
Yeah, but the main issue is you were not invited. You did not attend the hearing. I think that is the one of the critical issues. And then the rent is question is whether the judge rightly purged the contempt of the other two when the other two didn't seek for the contempt to be purged. And thirdly is Miss Jalaf, who is she representing for at the time, and until recently we do not know who she was. I think those are the three basic issues, if I can summarize. Do you agree with me? The rest are argument that support that. Yes, Mr. Peter.
The other issue I think Ms. Bijlani is raising are the terms on which contempt could be purged.
Yes.
So it's no hearing, what are the terms, and then the Al-Jalaf question, if I can call it that.
Yes. So yes, then please. Then we have read through the submissions, Miss Bijlani, and I was wondering we can sort of go to the main issues directly without having to go into the fine details. If we are not sure, we'll just seek clarification from you as we go along.
Of course.
Thank you.
I should just raise one point that's actually not in the skeleton argument. And I think the order that has effectively been made in September, purging the contempt, must surely have been made pursuant to RDC 4.9, which gives the court the power to make orders of its own initiative. and there's a similar provision in the CPR 3.3.
Yes.
But if you, we have a copy of that section of RDC. It's I think it's G16.
G16.
What rule is it?
RDC.
Yes,
So
what number?
perhaps it's G3. Sorry, it's RDC 4.9.
4.9. Yeah.
4.9, yeah.
And this is in the context of notification to the claimants and whether an application should have been made. But I think 412 says the court may make an order of its own initiative without hearing the parties or giving them an opportunity to make representations. And then 413 states where the court has made an order under Rule 4.12 in subsection 2, the order must contain a statement of the right to make such an application. And the order, which is at J1, does
do
not
that.
state that at all.
When the 413 says the order must contain a statement of the right to make such application, that such application refers to what does it refer to? A party affected may apply to, or you should state that they can apply to set aside. Is that what it means in 4132? The court has been
Yes. I think it's
or that order doesn't contain this statement that the
correct.
party affected may apply to have it set aside, varied, or state. And because that the absence of those statement or that statement, you are saying that the order is void, in nullity, ineffective.
Yes, and there's also relevant case law in the context of contempt orders, where for a case of this nature, it's considered that it's appropriate to hear from the claimants. And I can take you to one of the cases at J610.
Notwithstanding 411, making the order must
Yes.
discretion for the okay, just go ahead.
Yes, so I think I won't. I'm sure I probably don't need to take you to all these cases, but in the judgment that's referenced, it's talking about the application of 3.3 of the CPR, which is equivalent to RDC 4.9 onwards, and essentially saying for a case of contempt that the claimant should be heard in terms of the conditions of the contempt.
I suppose in special circumstances when the person is incarcerated, I suppose that's when the judge can make a decision quickly and to not continually unfairly detain the person. I assume that's why you have this provision in.
Yes.
Well, okay.
And I won't take you through all of the reasoned judgments. I've set it out in the affidavit, but I suppose I don't really need to take you through the background. But essentially what the claimant is saying is that it should have been heard, and that the contempt of Mr. Ali and Mr. Abuhushima should not be purged. And again, I won't take you through the cases that set out the criteria to be looked at in cases of purging of contempt, but it's the claimant's position that neither Mr. Ali nor Mr. Abuhushima have demonstrated that they are sorry for committing the contempt.
Okay, before you proceed, Ms. Bijani, sorry to interrupt you. Before you proceed, assuming we are with you on your submission, what does the appellant, or your rather, the respondent, need to do? What order will we be making? Setting aside the order of Judge DCJ Ali, and then because he has paid his principal amount. What he has not paid is just the interest. But in your application or your appeal, you are setting new additional requirements that the who is the appellant, the respondent is required to comply with.
Well, yes, Your Honour, I agreed that they were required to pay the interest, but the order of Sir Justice Jeremy Cook also provided at J375 that the defendants, Mr. Abuhushima and Mr. Ali, are liable for the costs up to that point, which were assessed at $288,000 on a joint and several basis.
Yes. Okay. Yes, I forgot about the cost.
Am I
He has
right
not paid the cost. Sorry, I beg your pardon. Yeah, Judge Glennie.
Am I right in thinking that you go beyond asking for the costs, though? You want the fine, you want the cost, you want the principal sum, and you want interest, but you also want payment of other amounts by way of damages for commencing proceedings in various jurisdictions. That's the thing that troubles me as to why you should be. They don't arise out of the freezing order or the contempt of that freezing order. They are actions which, right or wrong, they can take and suffer the consequences, if there are any, in those courts. Why should this court deal with those on an application for contempt?
Yes, Your Honour. I would submit that some of the costs do directly arise out of the contempt. So you may have seen in the skeleton argument that when the freezing order was breached, the claimant quickly tracked down the aircraft and found that it was in Malta. And bearing in mind at that time, nothing had been paid by Mr. Ali and Mr. Abushima. The full outstanding debt was outstanding. So the claimant was forced to commence proceedings in Malta, and it's been forced to continue those proceedings because as far as the claimant is concerned, it still hasn't been paid its interest or its costs.
But wouldn't that be a separate claim, a separate cause of action against the respondent? Do you take it at this hearing? I'm trying to simplify the issues. That's all, without going to too much detail, whether we need to decide on those issues. Because if we need to, then, the hearing is longer and our judgment will also be longer. Whereas for the moment, to my mind, I'm wrong. I may be wrong, but to my mind is you Judge Birch, and then you get him to comply with the order of Sir Jeremy, and that's it. And whatever claim you may have against him, it's a separate matter altogether, a separate action altogether. I may be wrong. I do not know. Of course, I depend on the views of my two other brother judges as well.
If I could just, sorry.
If I can just add to that a question which you might want to deal with at the same time, is, for example, the Maltese proceedings. Why wouldn't you ask the Maltese court to dismiss them and order costs or whatever may be appropriate, rather than bring it to this contempt proceeding?
Well, the proceedings in Malta are extremely slow. We started them some time ago, and there's no visibility as to how long it's going to take to actually get the order for sale of the aircraft. The aircraft is not being maintained. It's just sitting there and decreasing in value. And the claimant cannot recover those costs from the Malta court because the rules of the court do not allow it to recover its legal costs. In relation to these proceedings, we've had to, or the claimants had to incur costs in dealing with the purge application that it didn't receive notice of. There's been the exchange of skeleton arguments. There's, of course, the hearing today, and those costs have all had to be incurred.
Yeah, but if you have arrested if you arrested the aircraft in Malta, can't you bring it back? Again, I'm just I'm just
there are
asking
lots
you
of costs
because
involved in bringing an aircraft from Malta. We'd have to get the aircraft airworthy again. We would have to go to great lengths, having recently experienced this with a repossession of a Russian aircraft. I can tell you it's a huge exercise to get an aircraft ready to
so
fly.
you choose to go for damages against the that's fair. Going
yes,
damages against the okay, yes, Judge.
But we're talking about in this context, though, it's important to bear in mind that the there has been paid into court or into escrow 4.5 million odd, which is the principal sum claimed. And so when you're talking about the value of the aircraft being diminishing with time and the cost of making it airworthy and so on, you're talking about that in the context of a claim for the fine, the interest and the costs, which is a much smaller sum than originally claimed, because the main part of that has been dealt with by payment into court. Am I right?
Yes, that's right. But I suppose the only issue for the claimant is it had to start those proceedings when it did, because the principal hadn't been paid, nothing had been paid. And it's only several months later.
Let's break this down. You wanted the principal. That, as Glennie said, in effect represents the value of the aircraft?
No, not at all. That reflects aircraft management services that the claimant performed for the defendant.
So the principal is now in escrow, correct?
I believe it's actually been paid out to the claimant.
Okay, even better. So the principal is dealt with. Then you want interest. Then you want the costs of these proceedings.
Yes.
So far, I follow. It, speaking for myself, it all arises out of the failure to comply with Sir Jeremy's injunction. Now, what happens next? Malta. The aircraft was taken to Malta?
The defendant procured the flying of the aircraft to Malta in breach of the injunction, yes.
Okay, and you've arrested it there?
Yes, that's correct.
And in the fullness of time, with a bit of luck, you'll recover it there?
With some luck, but we will not recover the legal costs involved.
Okay, but how does that arise in the context of today's proceedings? I think that's what my lords are asking.
Yes.
Well, I suppose if you were minded to order the payment of interest and costs, I would really have, unless I have a damages award for other costs, I won't have a claim to make in Malta. So I'll be left with having to withdraw the proceedings and absorbing the costs because they're non-recoverable.
No, you can. Yeah, go on. Yeah, sorry, Peter.
No, not at all. Why are they not recoverable in Malta? Is that some Maltese rules of court?
I'm advised by Ganardo's, the law firm acting, that they're not recoverable.
Under Maltese law? Under
Maltese law.
Okay, well
yeah. But then you can still go after the respondent in Dubai or wherever he's located.
But the claimant admits that it shouldn't have to go to that expense and trouble in circumstances where it had a freezing order over the aircraft. It could have recovered everything had Mr. Ali and Mr. Abashima done what they should have done.
Yeah, my concern is this the proper forum, the proper course of action, for the proper way to claim that damages incurred by you? Is this proper at this stage, in this form? This is what I'm concerned about. Whether you can make such a claim in a breach of contempt order. That's bothering me.
Yes, I think I have included references from Guy on injunctions in the skeleton argument. Sorry, Guy.
G.
G. Sorry. Sorry. G. There's a KC called Guy that I'm confusing him with. But apologies. G. So I think paragraph 5, I explained from a section of that text that it's been said where the contempt consists of an injunction, damages can be obtained as a matter of discretion. And there's a case from 1994 that's also referenced where assets were seized due to a failure to comply with an injunction. And I appreciate the points that, you know, for example, the onshore court proceedings in Dubai could have been launched regardless. But what has been an ongoing theme throughout these proceedings is a complete lack of disregard and disrespect for this court. And not only has the respondents failed to attend hearings, and Mr. Ali and Mr. Abu Hashima failed to attend the hearing of their contempt, they did nothing about the order that was issued against them until the Attorney General of Dubai acted. And they just...
Sorry, Peter. Yeah.
As it seems to me, but don't jump on the bandwagon, because sometimes they don't go anywhere. But the best way I can think of putting your point is the Maltese proceedings followed directly from their failure to comply with the injunction. You had to go and find the plane and arrest it. And in those circumstances, you ought at least to be secured for the costs of those proceedings. I say secured because it may be that they should go into escrow rather than to you, but because those flow directly, without a causative break and not too remotely, from their failure to comply with the injunction. If they complied with the injunction, the aircraft would still be here, it wouldn't have gone elsewhere. You wouldn't have had to incur monies to go and arrest it. That, as it seems to me, is the best way you can put it.
Yes.
I was about to say much the same, joining the same travelling wagon. But the thing that troubles me, though, is if I can just move forward slightly in what you were saying, you place a lot of weight upon what you might call the disrespectful attitude of the respondent to the court. This court ultimately is not a court of vanity. It is concerned with the practical consequences of disobedience to its order. And I can't see that the attitude of the respondent to the freezing order and their lack of apology and so on, and the delay in doing things, can justify this court in making an order which is unrelated to the contempt. For example, the actions taken in onshore Dubai seem to me actions which could have been taken whether there was a contempt of the court order or not. And you can't bring them into recoverability simply by saying this is awful behaviour. Do you follow?
Yes, follow? Yes, I do follow. Yes, of course. But I would at least admit that the interest, the assessed costs of $288,000, the Malta costs, and the costs of these proceedings should be paid as a condition.
That I understand, and I suppose you would add the fine of 100,000. Was it?
It's $100,000 fine applied to the defendant, which, as far as I know, has not been paid.
Yeah, and that I could understand. I think subject to what the other judges think, but are you persisting in your, just so I know what is a live issue or not, are you persisting in seeking the costs on onshore Dubai actions.
No,
as
I accept your points, and but the claimant would, as I said, like to advance on the other amounts.
Sorry, Miss Bijlani, we have distracted you from the main main issues in your submission, but I was hoping that we can resolve these issues, then we can move faster. But unless the other judges have something else to say, I think you can go back to your original submission. Sorry about that, Miss Bijlani.
Yes, well, I suppose it's a question of where I go from here, because by the sounds of it, you don't need me to take you through the detail of course, you know the law extremely well, and you don't need me to take to the judgment. So is it just a case perhaps of me taking you to the details of the costs?
Yeah, I think go back and first you may wish to attack the judgment of DCJ Ali on that where he's gone wrong. I think you have briefly told us what he has done, and to support your by authorities or whatever it is to say he was wrong. It helps us in writing our judgment if you do that for us.
Of course. So we do have a section on this in the skeleton, which starts at paragraph 24, where, and I won't read it all out, but we set out the history of what's happened. So
as you go along, can you tell us I'm using this screen, where if I put the page number, it goes straight to that page. Can you help me by telling me J something? Or the judgment is J. What J is that, so that I can move very faster?
Of course. So the order on the 5th of September is at J1.
J1, okay.
And in the lead up to that order, Mr. Ali attended the DIFC courts and asked to purge his contempt.
Yes.
We were contacted by the court that day asking us to attend a meeting and advised that we needed client instructions because we couldn't agree to a purge without instructions. And then on the 2nd of September, we received the order, which you see at J1. And then there was an email from Mr. Ali on the 3rd of September, which is referenced at paragraph 29. And we've set out that despite the court having previously indicated that a hearing would be held, a hearing was not held. So I'm just trying to find the reference to the order. Yeah, so at I think it's J315. Apologies.
Yeah.
Where the order clearly states that there will be, no, it's not, just asking my colleagues to give me the right reference and I'll come back to it. But it essentially states that there's going to be a return date. There wasn't a hearing at all, and the order was just made. And then I've set out that RDC 23.4, this is paragraph 33 of the skeleton, states that the general rule is that an application must be served, notice must be served on each respondent, and no notice was given to Gulf Wings at all. And I've also taken you through what RDC 4.9 to 4.13 says, yes, where the court is
Yeah.
seeking to make an order of its own initiative, which is what I think the judge was doing on when sorry, I think that's what Mr. Justice Al-Madani must have been doing when he made the 5th of September, is exercising rights under 412, but the order itself, as we've discussed, does not contain the statement that's required at RDC 413 subsection 2.
Can I just be clear? I've been reading 24 to 28 in your skeleton, and it's clear from what you say that the registry contacted you and you were aware there were discussions of some sort going on about the purging of the contempt. Is that right? But
Yes.
your complaint is that it didn't result in someone saying, right, well, let's fix a hearing. You simply, the next thing you heard was that there was an order made which was circulated and served on you. Is that right?
Yes, that's right.
Thank you.
And so when the order was made, the claimants filed an application for permission to appeal the order. And that application was granted, but before the application was actually determined, the DIFC registrar called a meeting at the court on the 14th of September. And there's a recording of that meeting within the bundle, but it wasn't a very productive meeting because the claimant had said that they needed to have the outstanding amounts that Sir Justice Jeremy Cook had ordered be paid, and they being the defendant and Mr. Ali flatly refused to entertain a discussion about that. So it wasn't a productive meeting.
What was the purpose of the meeting?
I think the registrar ordered the parties to attend because she wanted to find a solution. I don't quite understand anything more than that about it. And we duly attended because she directed that we do so. And ultimately, we were granted permission to appeal, and then filed our appeal. And of course, this is the hearing of that appeal.
In terms of the rules, you apply to have it set aside if it's made without a hearing rather than appeal, but perhaps it doesn't matter.
Noted. Thank you.
That's it, really.
I mean, that's it, really. And I can take you to the details of the costs, if that would be helpful.
Just before you do that, I think the important point might be, quite apart from lack of notice of a hearing of any sort, the fact, as I understand it from what you say, there was no case put forward on behalf of the defendant that there was any urgency justifying going ahead without a hearing.
We're not aware of what was said to the court, and we were quite surprised, having received an order that there's going to be a return date. Because I think initially, I'll give you the reference in a moment. Initially, we were told that this money had been paid into escrow, and there'd be a return date. And then suddenly, this order on the 5th of September materialises, and yes, we were quite surprised because we felt that we were going to get the chance to make representations, and then did not have the chance. And we didn't receive at all notice of the application by Mr. Ali. I don't believe I'm not aware actually if he actually filed a formal application notice. I'm told he did, actually, sorry. But it was not served on the claimant.
Okay, is that you? What do you want to do now, Miss Vigilani? Do you want to have you left anything that you felt that we should be submitted to upon, or
I think that probably covers the points that the claimant wanted to make in relation to the background history in terms of the purging order and
Yes.
why we say that the purging of the contempt of both Mr. Ali and Mr. Abuhushima should only be on conditions of the sums that we've discussed, apart from the cost of the onshore divide proceedings.
Speaking for myself, can you just give me or give us a list of the figures that you're seeking, or at least the references where we can safely find them?
I think they're in the last paragraph, aren't they? Paragraph 94.
Yeah, that should do.
Yes.
That we can rely on that, can we?
Yes, there is a breakdown in the bundle. Sorry.
94 doesn't mention the fine
No.
of $100,000 US dollars.
I'd sort of.
What page is that? What
Page-
page is
J710.
A710? Okay.
J710.
Speaking for myself, I'd welcome just the figures, assessed costs or cost of today or fine or the costs in Malta, just so we know what we're talking about in one place. You've gone mute, Ms. Bijlani.
It's the costs are dealt with in the supporting affidavit of Mr. Khaldoon Al-Aini, which was sworn on the 23rd of November.
So what page is that?
That's J2.
J2. Okay, J2.
And if you go to paragraph 28.
What's that? J, what's that?
J6.
Yes.
Sorry, I'm being old-fashioned and working on a hard copy bundle. But sorry.
I'm struggling. I mean, I could take a screenshot of that
starts
page
at J2, I think.
That's the page, para 28. Right.
Yes, J6 is paragraph 28.
Okay.
That's correct.
Okay.
And there's a
take
breakdown of
screenshot of that. Try to take a screenshot of that. How do I do that?
So in those figures, A relates to the UAE onshore proceedings, does it?
that's correct, but some of those costs are dealt. Well, I think when we were trying to enforce the committal orders, and there's quite a lot of time spent dealing with the Attorney General office, because that's not really a tried and tested process. So I think that some of the costs in B will be in relation to actually enforcing the committal orders, and perhaps, I mean, I'd be happy to give a breakdown if that would assist following the hearing.
No, there were post-hearing submissions I don't like.
Okay. I could tell you prefer to dispense with it today, but I think for A, the costs are, and we haven't discussed this is costs before the judicial committee, because the defendant challenged the jurisdiction of the DIC courts, and that proceeding still yet to be determined.
It's nothing to do with contempt, is it?
Correct, yes. I accept that. And in B, we have the costs of defending the onshore Dubai courts, which we've discussed should not be recoverable here. And in C, we have the costs of Ganados, who are the lawyers in Malta. And then in D, we have the costs of Watson Farley Williams. I suppose the difficulty is we've got costs of managing everything as well. And there's a footnote at the bottom which details, as at the 26th of October, the costs that have been incurred in connection with these proceedings, in addition, but they're unbilled costs, which are in addition to the 331,643. And also, those figures do not include the $288,000 that were ordered to be paid and which are referenced in paragraph 29.
Can you assist me in particular with some authorities to say that you are entitled to these costs? Because the way I see it, I think some of them are outside the scope of, but can you, is there authorities on cost relating to this? Or I have to rely on my learned brothers who are more familiar with this procedure in the English courts than I am.
I think that from the claimant's perspective, the losses that we're claiming in relation to the Malta proceedings and these proceedings directly flow from the breach of the injunction.
Based on the authority you cited earlier on in your submission, skeleton submission.
Well, I think that the losses directly flow. I mean, I have referenced in the skeleton argument some of the legal commentary that we say is in support of a damages award being made. And we say that's paragraphs 75 to 78 of the skeleton argument. But I think the main point is that these losses flow from the breach of the injunction directly.
Yeah, okay.
Just your footnote 2, at the bottom of J6, bottom of page 5. We're talking about Watson Farley fees incurred after 26th October. That would presumably be mainly the UAE proceedings and the JJC, wouldn't it?
Well, the costs after 26th of October have been mainly in preparing for this hearing.
$80,000.
So the $80,000 is what we solicitors call work in progress, so unbilled time. So we've got that in the system, but we haven't billed it. And from the 26th of October, we'll have incurred additional time in the run up to this hearing, including today.
Well, one answer, if we're otherwise with you, is to make an order which obliges the respondent, as I call them, to pay money into court, but not to pay money to you, so that as far as costs go, they can be assessed by the registrar if not agreed. Because speaking for myself, I'd be very wary of making anything which looked like an order that a lot of these sums are simply paid to you. Somebody's going to have to go through the costs rather more carefully than we would.
I totally agree with you, Josh. I totally agree with Sir Peter. I think that's the best we can make at this stage.
I agree.
We can secure you. That's it.
Yes. Could I just ask for just on one point of clarification? So we would submit to the registrar all of the invoices and supporting information to substantiate the costs, and then if they're not agreed, by Mr. Ali and Mr. Abuhashim and the respondent, then the registrar would look at them and decide what amount is due.
But in the mean, yeah, go on. Yes, please. Go on, Peter.
I just said to Ms. Bijlani, if we're otherwise with you, and we made an order of the sort I flagged, then as the Chief Justice says, that's what would happen.
Yes. Yes.
The only slight glitch in that, I agree in principle, is the Maltese costs, which won't have been the subject of any assessment in Malta, and I don't know whether the registrar would really have any feel for what Maltese costs should be.
No, we might have to take a stab at that.
Yeah.
They're far more reasonable than the cost of lawyers in London and Dubai, I think. It's my take on it. Of course, we can provide the engagement letter and the invoices to the registrar.
Okay, we'll want to hear what the other party has to say as well. You know. So, how urgent is this order that you're seeking to set aside the order of Judge Ali? Is it very, very urgent? Require urgent decision from us?
Well, I think it's been some time since Mr. Ali's contempt was purged, and inadvertently Mr. Abuhashima's contempt has been purged. But I suppose the claimant would like an order so that it can then start the process with the Attorney General if that's the route that it has to take again. But I appreciate you need time to prepare the order. But it's not as if today I must have the order. No, that's not the case. It's more the case that the summons that the Attorney General had issued has been released, and as at today, there's no immediate pressure on Mr. Ali and Mr. Abuhashima because the past has shown that they won't take notice of the order until the Attorney General actions it.
The reason why sometimes this court has made an order and give our reasons later, because sometimes writing the judgment takes longer. But if there's no, we are more comfortable in taking a bit of time, going through writing our judgment and giving the order. Then that's the only reason why we ask you.
Okay.
It's like, for example, in seizure order to arrest, we have to give an order immediately. We cannot wait. Or in the injunction, Mareva injunction, we give an order immediately and give our reasons later. But in this case, I think a lot of water has passed under the bridge, and there's no real terribly urgency in having to make the order. Would you agree to that, Mr. Bijlani?
Yes, I agree.
Okay. So if you have finished with anything else you want to add?
No, that's it. Thank you very much.
And judges, any questions from you?
Not from me, thank you.
Okay, thank you very much. So we'll hear Miss I'm so sorry.
Al-Jalaf.
Yeah, Al-Jalaf. I'm sorry. Al-Jalaf. Apologies. Al-Jalaf. Yeah, Miss Al-Jalaf, we'll hear from you then.
Okay. I also would like to have a background about the case. In the beginning, I just want to mention that Mr. Abuhashima and Mr. Abu Ali was sold their share of this company back on 14th of in October 2001, and they didn't. They was in the process of changing the ownership at that time. Also, the aircraft subject matter was deregistered on the 23rd of November, and it was registered in the US jurisdiction. So the contempt, which is issue actually, which is the order which is issued on 14 of January 2022, was impossible to execute it because the freeze of aircraft is no longer exist in the under registration of the General Civil Aviation Authority of UAE. It is already registered in the US because the order was after the aircraft was deregistered.
Under whose control would the aircraft be during this period?
It was controlled by the new owner, and it was very clear mentioned to Judge Jeremy at that time. This aircraft is no longer in the UAE and is no longer under the authority of the two shareholders.
No, the aircraft was physically in UAE. It was physically in UAE during Judge Jeremy's judgment.
Yeah, but
he was flown out to Cairo only after he made the order.
Yes, but the aircraft is not registered under UAE flag. It was deregistered under US flag in the 23rd of November 21. So the aircraft wasn't under the authority of UAE civil aviation. That's
Yeah,
why
but you were then the owner. You direct where your client direct where the aircraft to fly, isn't it? No.
The owner, the new owner was the controller of the physical aircraft.
So who directed the aircraft to fly to Cairo?
The new owner.
You have evidence to that?
Yeah. We mentioned it many times to and we submitted to the court, and we try to show that the aircraft is not under UAE flag, is not registered in the UAE. Physically, it is in the UAE, but when the new owner requested to move it for maintenance, the Civil Aviation Authority, they give him the right to fly it, and that's why they take it over.
Ms. Al-Jalaf, speaking for myself, two questions.
Yeah.
One, Sir Jeremy Cook didn't accept that, did he?
No.
And there's no appeal before us from Sir Jeremy's ruling by you, is there?
No, because we believe both company was outside the jurisdiction of the DIFC, and we believe that the jurisdiction is for inshore court.
Okay, well, if that's right, then you haven't got an appeal before us, so that's the end of that, isn't it?
Yeah.
Right. Well, that can't go anywhere if you're not appealing.
No, I'm just trying to explain that the contempt of the itself is not really intentionally happening, because the aircraft wasn't under their control and the aircraft was registered in different jurisdiction. So it's not intentionally they moved the aircraft to cause damage for the claimant.
My second question, who do you represent?
Yeah, I do represent A and K director, Mr. and this specific contempt hearing, Kamal Abu Ali.
And he is still a director of ANK, is that right?
Actually, his paperwork is through the procedure in order to change it, because he sold his share back in October 2001.
Miss Al Jalal, can you your picture is not Al Jalal.
Getting it.
Your picture is not there. Can you put your picture on the screen? Is there any
Yes.
objection to that?
No, not at all.
I don't see your picture.
I didn't
It
see
is
that.
there.
No, I don't.
No, it's black. It's blank. Black.
I don't
Turn
know.
on the camera.
Maybe your camera. Turn on your camera.
Yeah, it isn't.
Your camera.
I haven't got a picture either.
It's blank. It's black. Shala,
No.
can you assist?
Anybody can see me?
No?
No.
It's a black.
Mr.
black.
Jalaf, please sign out and sign back in again.
Okay.
Shala, what's happening?
Yeah, Your Honor, I think she's still trying to sign back in.
Yes. Still not there. Who's from IT? Can you help? Somebody from IT?
We're in
Who's
touch
from
with her,
IT
Your
on
Honor.
duty?
We're in touch with Mr. Jalaf, Your Honor.
Where is she? Where is Miss Jalaf submitting from or speaking from? Shala,
Your Honor, I'm calling her law firm right now to see what's happening.
is she in Dubai?
Yes, she should be in Dubai.
Oh, I see. I think as matter of course, next time you should have their mobile numbers because going through their firm takes a long time. You should have a direct contact with the person. As matter of course.
Sorry to intervene. I do believe Miss Al-Jalaf's colleague is on the call. Ehab, I don't know. Can you share the mobile telephone number?
Your Honor, I'm on the line with Al Jalaf's law firm, and she's trying to log back in again. She's getting some assistance. She'll be here shortly.
Okay. Thank you. Thank you.
Ms. Amla Jalal, can you hear me?
Yes. Can you see me now?
Yes, we can see you. Chief Justice, we're ready for you.
Yeah, sorry for that.
We can see you now. Yeah.
Yeah.
Okay,
thank-
great.
Yeah.
Now we know how you look like. You have not appeared before me, so I cannot guess how you look at. Yes,
No,
Miss Al Jalaf.
yes.
You were saying just now, but reading from your submission is very simple. Your submission is merely saying that, as you rightly pointed out during the submission earlier on, it's very simple that you are not the owner and you have no control over the aircraft, and therefore the decision was of Sir Jeremy was wrong. And but the only point that's very strongly against you is, why didn't you appeal against that decision? You did not appeal. If you did not appeal, then you stand by the decision of Sir Jeremy as
Yeah,
far as ownership and control of the aircraft is concerned.
yeah, because we believe that this case can be heard on shore because both company are on the UAE and outside the.
Did you challenge the jurisdiction of Sir Jeremy when the matter was filed?
Yeah.
You challenged the decision?
Yeah. Yeah.
Are you sure? Because
Yep.
in the Sir Jeremy contempt judgment, the one we're
We-
concerned with.
We
Sorry,
mentioned.
let me finish for a moment. In
Yes,
Sir Jeremy makes the point that there was no challenge to jurisdiction within the time allowed by the rules. Is that right?
We send in our skeleton that is lack of jurisdiction, but he didn't get it in the consideration. If I can just also add two things. One is because the discharge from Mr. Ali for the contempt order. Also, Abu Hashima, he filed discharge directly to the General Attorney of Dubai, and he get discharged. The General Attorney reconsider the whole conduct order, and his decision is to discharge Mr. Abu Hashima.
No, you're going far ahead. We are going backwards. Go back to when Sir Jeremy made the order. We are at that stage first. In answer to my question just now,
Yes.
that Sir Jeremy has made the order, and you contended that just now that you raised the issue of jurisdiction, but
Yeah.
Sir Jeremy ignored you, did not decide or decided against you on that issue.
Yeah.
But according to Justice Lord Glennie just now, that there was no mention of this, or rather, Sir Jeremy did mention that the jurisdiction was not challenged. So how do you answer that?
If I can just
Yes.
help, it
Yeah,
is
please.
dealt with in paragraph 21 of Sir Jeremy's judgment.
That's page number what?
Page number J380.
380.
It may be an
Yeah.
earlier page too, but paragraph 21.
The defendant, without issuing an application, wrote to the court seeking stay. He was unable to appear on this court because he had filed an action of discharge of debt before the court. So there was no question challenging the jurisdiction at all. So if that's the case, then his judgment stands. If his judgment stands, then his order stands. So if his order stands, then how can you now argue against that? Because you didn't appeal. You have accepted his decision as the correct decision, Miss Al-Jalaf.
I do believe we put in our skeleton that in front of Judge Jeremy that the challenge.
Yeah, but you did not formally apply because he said without issuing an application.
Yeah, well,
You just wrote to the court and say you have no jurisdiction, but that's not the proper procedure for challenging on jurisdiction.
Yeah, we took the other channel, which is the onshore, to challenge the jurisdiction through the Dubai court.
You don't challenge your jurisdiction in another court. You should challenge your jurisdiction in that court where you're appearing. That's very difficult for us to even if we want to help you, that point is very, very much against you. I better tell you now. So if that's the case, then your issue of challenging decision does not arise.
And even
Okay, never mind. We'll pardon? Yes,
Yeah.
just going to say that even if there was a challenge to jurisdiction before Sir Jeremy, there's been no appeal against his decision refusing that jurisdiction argument.
Sorry.
No, I was saying that even if you mentioned jurisdiction in the proceedings before Sir Jeremy,
Yeah.
even if you did, he found against you. He ruled against you. He ruled that the
Yeah.
court had jurisdiction. There's
Yeah.
been no appeal from that decision.
Yeah, because if we appeal the decision, then we have no right to go to the onshore for challenging the jurisdiction.
Well, that may or may not be correct. I can't see why it is, but even if it's correct, you still have to, if you want to challenge jurisdiction of this court, you have to make an application to this court by way of appeal against Sir Jeremy's decision, and you haven't done that.
Yeah, because we decide to go to the onshore court in order to do that.
Right.
Okay, well, that leaves us with Sir Jeremy's judgment.
Yeah.
And paragraph 23, he says what he says about your case on the transfer of ownership. He wasn't very impressed with it.
Because the change of ownership, it was happening actually before even the case was filed, and
Stop, please. Yeah. Paragraph 23 is very straightforward. Sir Jeremy didn't believe your case.
Yeah.
You haven't got an appeal against that. That's the basis on which we're approaching it.
Yeah, as I said before, that we decide not to challenge this in the DIC court and go to the Dubai court.
Right. That's your decision.
Yeah.
Okay.
But we must proceed on the basis that Sir Jeremy's order and judgment is not challenged in this court. You've disappeared.
We've lost Miss Al-Jalaf.
Al-Jalaf, where are you?
We've lost
Where
her.
are you?
That's
Maybe the signal's very weak. That's why they don't use the video. The signal is weak. Perhaps you should.
Here we are.
Miss Al-Jalaf, if you have problem
Yeah.
with your video, I think I would excuse you from turning your video on so that you save on the
Okay,
broadband speed.
Thank you very
Okay,
much.
we'll just hear you. Okay,
Yeah.
go on.
Thank you.
Yeah. So your answer to those questions is that you filed an action in the Dubai courts, and but as my colleague, my brother judge said, is that the judgment of Sir Jeremy stands as far as we are concerned. And if it stands, then we have to take that as a set of facts that is appearing before us now. We are giving you advance notice so that you give an opportunity to defend yourself, Mr. Al-Jalaf. Okay, go on the next time. Assuming we reject, well, assuming you're right there. I mean, it's a question of fact whether we accept your contention that the aircraft was now registered in US, A, and B, the ownership is under somebody else's, and that your clients have no control over the aircraft. Those are your defense, basically. But the fact that you went to purge your contempt means to some extent you accepted the the contempt order. And you don't challenge the decision of the Sir Jeremy at that application to set aside the contempt. Instead, you went and purged the contempts by paying the money in. That is also sort of amounts to your admission that the contempt order was correctly made, except that you are now purging the order. I'm telling you, my way is I always tell you what is in my mind.
Yes.
Give
Okay.
you an opportunity to defend, to explain yourself.
As I
Yes.
said, because I don't want to.
Okay, you,
Yeah.
okay.
Yeah.
Yeah. Any other things, Miss Jalaf?
Yeah, I also would like to refer any cost and
Yeah, can you submit on the costs? That is your defense, is it? Your defense is very simple. The aircraft is not under your control because it has been transferred to somebody else now. That is your defense. And therefore, the contempt was wrongly, or contempt order was wrongly made against your client.
any cost related to this case. I think the claimant have to follow the same procedure through because the defendant is not in the IFC. They have to follow the procedure that to file the execution through Dubai court in order to get all the full judgment expense, and not through the conduct.
If you argue that this jurisdiction has no this court has no jurisdiction, how then this party, your respondent, go to Dubai court and claim that the cost?
Yeah, this is the procedure.
That's how you understand it to be.
Yeah.
Okay. Normally, you apply for cost in that same court. If you come
Yeah.
to the IFC,
It's not about the cost. It's not about the cost. I mean the whole claim amount.
Anything else you want to say?
No, this is all from my side.
Have you got anything to say about the DCJ hearing and making the order without the other party being present or giving an opportunity to defend themselves? What do you have to say to that? Is there anything you want to say?
And nothing from my side, because actually my client was appear in the IFC court by himself.
Or by himself? Okay, okay. Yeah, that's right. He appeared himself. He doesn't have, you were not instructed to appear. Okay. Okay. And then many times questions were put to you who you were representing, and you just sort of reluctant to.
No, I didn't react. I just explained it, but they insist on the same question all the time. I'm representing A and K directors, and in this case, I represent A and K director, Mr. Kamil Abu Ala.
You are not representing the individual parties.
No.
So the interpretation is not here. We don't hear them.
Sorry?
We don't hear. You are representing the company.
I represent the director.
Individual directors.
The second directors, which is Abu Hashima, was
Abu
already.
Hashim.
Yeah.
No. Our question is very simple.
Yes.
Who are you representing?
I'm representing A and K directors, Mr.
A and K directors of A and K.
Yes.
I.e., who are they?
They are now is only Mr. Kamil Abu Ala.
Kamil Abu Ala, and the other one?
Abu Hashima is no longer director. His
No.
name is removed.
No. The other person, you are representing only one person.
Yeah.
So you are saying that Ali and the other party is not represented here.
No,
Who are subject to the contempt order?
both of them, but the other one is already submitted a request to the general attorney, and he get discharged from that.
That is not final. If you hear the arguments, that is not final.
But,
I mean, if we set, if
nobody
we decide
challenged
to,
that.
if we have decided to set aside the order of Deputy Chief Justice Ali, then the thing starts all over again.
Yeah, but I refer also to the Mr. Jeremy decision where he said that this matter should be referred to the general attorney for the consideration.
That is because he decided that your client or the parties committed contempt.
Yes.
Okay.
And then
that is why he referred to the Attorney General. The Attorney General is taking instructions from the court.
yes,
If the court now says that contempt order should have been issued or should not have been issued, then the what do you call the Attorney General, is out of the picture.
yeah, if the court decide there is no contempt, there is the general attorney is out of the picture.
If the parties are not appearing before us, how can we decide in their favor or one way or the other? Who is appearing before us now? I want to know who is appearing. Let's make it clear who are the person. One is A and K directors, but is A and K directors a party of who are the parties of this case? Gulf Wing and NK Trading. NK Trading, who are the directors? You said
For
now
is only Mr. Kamel Abu Ala.
So you are appearing only for Kamen.
Yes, because he's the only one as a director in the registry.
Okay. Now, the other party, who was that? Ali. Abu Ali.
No, this is Mr.
No, Ahmad Abu Hashim.
Yes.
There are three. In the original case, there are three parties. There is A and K Trading, Ahmad Abu Hashima, and Kamal Abu Ali. Three persons.
Yeah, Ahmad Abu Hashima, right? He's no longer in the director.
So you're not representing him?
Not in this case, no.
You are representing only Kamal Abu Ali?
Yes.
And A and K Trading?
Yes.
So Ahmad Abu Hashim is not being defended in this hearing, in this appeal today?
Because he's not director anymore.
No, doesn't matter why. It doesn't matter why, but he's not here because you're not representing him, and he's not here in person either. I want to make it clear.
Yeah, because as I said,
we have to make a decision. We cannot say you submitted on behalf of Abu Hashima because you are not representing Abu Hashima. You are representing only Kamal and AK Trading.
Just I can make sure I can make it clear here because Ahmed Abu Hashima, he submit a request directly to General Attorney and to reconsider the order, and the General Attorney discharged him based on that request.
So there is no order by the Attorney General against Ahmad Abu Hashima.
Yes. Yeah.
Now, assuming we decide otherwise and set aside the order of Judge DCJ Ali, then the judgment of Sir Jeremy stands.
Because Judge Ali, he mentioned only one name.
Okay.
Just Mr. Kamel, Abu Ala.
Any questions from the judges?
No, I have no questions. Thank you.
No, thank you. Nothing from me.
Anything else you want to say, Miss Al-Jalaf?
No, thank you.
Thank you. So, Miss, do you want to respond to what the Miss Bijlani? Any response?
And just a few points. In the DIFC main proceedings, A&K Trading did file an acknowledgement of service on the 24th of January, stating they intend to defend all of the claim. They did not, as you pointed out, file a formal challenge of jurisdiction, and no appeal was filed against Sir Justice Jeremy Cook's ruling. And as you know, the reasons given by Sir Justice Jeremy Cook fully explain why he didn't accept the arguments about the re-registration of the aircraft in the name of TVPX and so on. He was very much satisfied that Mr. Ali and Mr. Abu Hushima were the directors and shareholders and failed to act as they should have done to ensure the injunction was complied with. And the only, another point is, I think I referred to earlier, is the email that Al Jalaf advocate sent to Watson Farley on the 29th of November, and that's at G26. It's just so that you're clear, they've stated they act for the defendant company and Mr. Abu Ali.
G26, yes. Okay.
Yeah. G26 or J26?
It's G26. 26.
So
There's a problem with that. My G finishes at 15.
I know.
Is it?
G26.
So I can't.
You put G27 just now.
I don't have a G. My G finishes at 15.
G8, sorry, I'm informed. It's on the live bundle at G8.
G8.
Okay.
G8, okay.
Representing A&K Trading and Mr. Abu Ali.
Yes.
In a limited capacity, but not Mr.
Hashima.
Yeah. Abu Hashima.
Not Mr. Abu Hashima.
And Al Jalaf did appear to take instructions from Mr. Abu Hashima previously. If you refer to paragraph 16 of the reasons of Sir Justice Jeremy Cook's ruling.
Can you put that page again? What's the page?
It's J378.
Yeah, you put it there so that it goes straight to my screen. J378. J378.
And paragraph 16.
Yes, paragraph 16. The defendant was represented in the parties hearing by the firm which was authorized to act for power attorney issued by Abu Hashima in my capacity as member of the board. Al-Jallah, when asked, said she had received instruction Abu Hashimi, but was coy about identity of the shareholders and directors and reluctant to party. Yeah.
There's something very basic about Mr. Abu Hashima's position. There is an order from Sir Jeremy against Mr. Abu Hashima, finding him in contempt. That's J375.
J375.
J for Juliet 375.
Okay.
And that is, well, if one looks at paragraphs 1 to 5 of the order, it's there. The order of the Deputy Chief Justice only purges the contempt of Mr. Abu Ali. Am I right about that?
Yes, that's right. But I think the difficulty is that the Attorney General Office treat the matter as one file. This is what's been explained to me by local council, because it's one complaint, even though there's committal orders against two individuals, because it's one case reference.
But without, forgive me, That's why I'm asking, and I may simply be wrong. Have we lost the Chief Justice? No, don't think so.
Chief Justice, are you there?
I'm here. I'm
Hey,
listening to you.
This may be, I may just be wrong. There's an order that Mr. Abu Hashima is in contempt.
Yep.
There is no court order that purges his contempt. What are the Attorney General's powers to do that of his own accord without a court order? I just don't follow that. Moreover, Mr. Abu Hashima is not represented today, so there's nothing from Ms. Al-Jalaf which we can take into account on Mr. Abu Hashima's behalf. At the moment, there's an extant court order against him.
And if I may add, the email we were referred to at G8 makes it clear that Ms. Al-Jalaf's firm quite recognised that the order only relieved Mr. Ali from the contempt order, and that it remained in place against Mr. Al-Jalaf, Abu Hashima. That's why he's not represented, because nothing that Deputy Chief Justice Ali did affected the contempt order against Mr. Abu Hashima. I think.
I don't know. Can somebody
Yes.
assist?
Can I just point out that Mr. Abu Hashima has authorised Al-Jalaf in the onshore Dubai proceedings by a power of attorney, which is
Wow.
at J12, and
Well, he's not. They don't represent him on this appeal.
No.
I think.
that appears not.
No. Well, there we are.
But I think to get the Attorney General office to start the process again, I'm advised by local council that we need another letter from the DIFC courts, again making a referral of the case to the Attorney General.
I'm just a little troubled. It may not matter, because if we're with you, we can certainly do that, even if it's declaratory. But I'm a little troubled as to how, without a court order, anyone else has the power to purge someone's contempt when a court has ordered that they are in contempt. That's a rather concerning issue.
I'm not sure if I can just chip in. I'm not sure that the Attorney General's decision purges contempt. If you look at 65.2, Justice Sir Jeremy Cook simply referred the matter of their contempt to the Attorney General for review and consideration of committal. If he decides not to commit or not to pursue that, that's not purging their contempt. It's simply not taking action when he's authorized to take action.
Right. I agree with you there. I agree with you very much. The contempt is ordered by the court.
Yes.
Consequence of the contempt, the AG then takes action against. If he doesn't, then there's no action. Otherwise, but the order of the court remains.
Well, we could send him another letter.
Okay.
Could I just make one brief point as well, which the claimant finds confusing, is that the skeleton argument filed by Al-Jalaf advocates invites the court to revise the discharge order, including Mr. Abu Hashima. This is paragraph 3.2 of the respondent's skeleton argument. So they invite this court to reject the appeal.
Including Abu Hashima.
Yes, thank you.
Strange for Miss Al-Jalaf to not representing Abu Hishima and yet seek for an order to that effect.
So what paragraph was the skeleton? Was that
3.2,
3.2?
the last
J
paragraph.
J718. J Juliet 718.
Thank you. Yes.
Okay, there's a lot of confusion here. Okay, there's anything else, Miss Vigilante?
Vigilante. It's okay.
Vigilante, Vigilante.
The only point I thought I'd make is that there is within the bundle some substantiation of the costs incurred. So from J249 onwards. Sorry, I'm having problems with the bundle because it's changed on the. If my colleague will get the live page because
Yeah,
but there's a statement. There's a summary of all the costs incurred apart from unbilled costs and supporting invoices. Just for your reference.
This is what you want actually. This is what Peter was asking just now. How do I make a copy of this? Download it.
It is J249 onwards.
Yeah, J249. Okay.
And that was put into evidence as as exhibits to the affidavit.
Okay. Okay. If there's nothing else, that's all, Miss Vigilani?
Yes, thank you.
Okay, we're going to leave the screen. You for the council, remain there. Don't go away. We are leaving your screen. We'll come back again in maybe 20 minutes or so. 20 minutes. We'll have our own discussion and we'll come back to you. Okay?
Okay, thank you.
So judges, we leave this and we go back to the other link.
I'm not sure how to leave, remain.
You leave now, go back to your email,
Yeah.
look for the judges link and press that again. Hopefully you get it. Sometimes I don't get through, but let's try. Otherwise, Cheryl has to set another link for us.
So hang
Okay,
up.
we leave now. We leave now. We go back to the email and press join in the other side. Okay, are the parties ready, Shala?
Mr. Jalaf, are you on the line?
Yes, I am.
Okay, all the parties are here. Okay, we have had time to consider and we have already made a decision. So these are the orders that we are making. One is we allow the appeal with cost to be determined by the registrar unless parties agree to it. And the order of Deputy Chief Justice Ali is set aside. The order, the order of Justice Jeremy Cook is restored or reaffirm whatever it is. And then the registrar will write a letter to the Attorney General explaining what had happened. The appeal has been allowed, judgment has been set aside, and the order of Jeremy is to make it to avoid any confusion. Judge Jeremy made an order in paragraph 4, I think, that contempt the two persons mentioned in paragraph 4, i.e. Hashima and Ali, committed contempt. So those orders are restored. There'll be other orders relating to costs and that will be relating to the purging of the contempt if there is an application to be made. These we will include in our written judgments, a brief written judgment that will be issued later. Am I clear? Any clarification, parties? Do you need any clarifications from us? Ms. Vigilani, are you happy? Are you clear with the orders?
Could I just clarify for the last point? I think you said that there'll be other orders relating to costs.
Yeah, because if you are seeking, if the party is seeking to purchase contempt, the order, remember, the order of Jeremy, Judge Cook stands. Okay?
Yes, yes.
If they're seeking to apply to purge that contempt, they were to apply seeking. That when that happens, then the judge, we will be writing guidance for the judge when making an order to purge, to make whatever orders relating to your expenses, cost that you have incurred in the trying to arrest the aircraft, and but not, of course, not including your cost in the Dubai courts.
I see.
It's clear?
Okay. Yes, that's clear.
That you have to appeal, you have to argue that before the judge, before whom you are seeking to, or the other party is seeking to purge the contempt. But we'll be writing some guide to the judge to make a decision in that aspect.
I see.
You clear?
Okay.
Okay,
Thank
clear?
you. Thank you. That's clear.
And then I think that's the order. That we have to allow us a few, maybe couple 2 or 3 weeks to come up with the. Is that clear, Registrar? Are you clear? Shahla,
Yes, Your Honor. Yes.
are you clear
Yes, Your Honor.
with the orders? Miss
Yes.
Al-Jalaf, are you clear with the orders?
Yes, yes, it's clear. Thank you.
Okay. So
Sorry,
with
could I
that,
just ask one more question? The
Yes,
first
please.
point where you say you allow the appeal with costs,
yes,
and the costs are to be determined by the registrar. Presumably, that's just the costs
of
that have been
this appeal.
incurred in these proceedings.
Yes, only
Um,
this appeal.
okay.
Only this appeal.
And that's what the registrar
Only
will
that.
determine.
Yes.
The Chief Justice said in the written judgment in due course, it will reflect the arguments on how much or what sums are relevant should there be a further application to purge contempt. But we are not dealing or fixing those sums today or giving guidance today on that, because we need to reflect further on that. But that doesn't impact on the orders with respect the Chief Justice so clearly given.
Thank you very
Yes,
much.
thank you.
Thank you very much, Justice Gross. So you're clear, and Ms. Al-Jalaf, it's more important that you understand the orders.
Yes, I do.
Very good. So with that, thank you very much. Is what time in Dubai now? It's 4 o'clock
It's
in Dubai.
12 minutes
Go-
past 4, and
you
we're
go and
just
have
about
your-
to have a long weekend because it's
Yeah,
public
good luck to
holiday.
you. Enjoy yourself. Oh yeah, you are having. Oh, Monday is a
We have
holiday
the
for
hearing,
you, isn't
so we're
it?
working, I'm afraid.
The
But
Emirates
yeah,
Day, Emirates
it
National
is
Day.
National Day.
Yes,
It is indeed, yeah. Yeah.
Then for us judges, we are going to have our lunch, and I think I see the sun coming out in London.
It's a rarity at this time of year.
Yeah. So
Aye.
to my colleague judges, thank you very much for your.
Thank you.
Thank you, and to the parties,
If I can
thank you
just,
very much for. Yes,
Thank
Judge.
you.
Shala, if you want to run the draft order past me before you issue it, just send me an email.
Yeah.
Yes,
Sure.
we'll do, Your Honor. We'll
Thank
do,
you.
Lord Glennie. Yes, thank you.
Thank you, everybody.
Yes,
Thank you very
yes,
much,
send that.
Lords. Thank you.
Thank you very much to everybody. All the best.